Welcome to Breaking History. I'm Tim Huebner. I serve as the chair of the board of editors of the Journal of Supreme Court History. And the purpose of Breaking History is, of course, to highlight new articles, new scholarship on the history of the Supreme Court. And with me today is Zach Jonas, who is the author of a really fascinating article that we're going to talk about here in just a moment. It's an article published in volume 48, number 2. It's the journal that looks like this, and it's called FDR's Court Packing and the Struggle for Civil Rights. Zach Jonas is a senior associate at the Rabin Group, where he provides strategic consulting services to help clients advance good public policy across a range of issues. A graduate of Georgetown University Law Center and Union College, Zach has also published work on the Supreme Court statutory interpretation doctrines and a state-by-state analysis of domestic terrorism law in the United States. Welcome, Zach Jonas.
Thank you for having me.
Well, so you've published this really fascinating article on Black politics and the court packing plan. So tell us kind of what your thesis is and sort of what you found as you delved into this topic.
Absolutely. So I think the big sort of finding of my research was an as yet undiscussed but crucial, I think absolutely crucial aspect of FDR's court packing plan, which is that the Roosevelt administration was directly reaching out to civil rights groups, and specifically the NAACP, the National Association for the Advancement of Colored People, for help on the court packing plan after the public backlash. But despite direct appeals from Aubrey Williams, who was a sort of Roosevelt administration official, the NAACP, decided to stay out. On the other hand, some civil rights organizations, including the arguably communist NNC, National Negro Congress, actually came out swinging in favor of the plan with their president or sort of head, a black lawyer named John P. Davis, another Harvard-educated black lawyer, actually testifying before the Senate Judiciary Committee about the court packing bill. And what I discovered in a long research process was that I actually looked into the NAACP's meeting minutes and saw that they had seriously discussed the issue at the national level, but didn't actually record their reasons for saying so. I think it quite literally said it was discussed at length, and then we decided not to intervene. And I was like, oh, come on, guys, you couldn't record your reasons for historians looking backwards. But
Right, exactly.
so instead, to sort of explain why the NAACP decided to stay out and the NNC decided to get engaged, I looked at the process of that decision, of those decisions, and the political context in the Black community and the civil rights community during that era. And I found that there was a conflict between sort of more radical young lawyers, including John P. Davis, but also Charles Hamilton Houston, William Hastie, who are actually members of staff of the NAACP. And they wanted to intervene. They wanted to come out swinging in favor of it, which aligned with what was then their conception of a more economically focused civil rights, a civil rights that was not just what we might today consider to be sort of civil rights in a narrow, citizenship-focused way, voting, education, but included a broader set of economic rights, including the right to strike, the right to unionize, right to equal pay, a sort of a whole suite of things that the NNC, with its sort of communist leanings and affiliation, they were already there. They were already talking about civil rights as an economic issue. The NAACP, on the other hand, traditionally had not been there. Some of the younger folks in the 30s were getting there, but they never actually made that final commitment. And this was a point, the court packing plan was a time at which they could have made that decision to alter or to sort of go in a different direction towards this broader economic, sort of more left popular front idea of what civil rights might be. And instead, they decided to stick with their existing priorities, which at that time were primarily the anti-lynching bill.
Right, thank you. And it's a fascinating story. I mean, because as you know, a lot has been written about court packing. It's certainly one of those topics that's attracted a lot of attention from scholars over many years. But much of that scholarship focuses really on members of the Congress, members of the Senate and the House, or the justices, or the president. But here you've sort of found this other angle. I mean, you're looking at, interest groups, and you're looking at, those who are outside of Congress, who are not necessarily, part of the sort of traditional way that we've studied this topic. So how did you find this story? How did you get sources? How did you know that this story was one that's obviously so worth telling?
That's a great question. I was actually at the Georgetown University Law Center. I was taking a course on American history with Professor Dan Ernst, who's a wonderful historian and an
Yes.
excellent teacher as well. And there was a sort of American legal history course where he presented that testimony, the testimony of John P. Davis, the black sort of left-wing lawyer from the National Negro Congress to the Senate Judiciary Committee. And he was the only black person to testify in like 20 or something days of testimony. It was this really vigorous testimony. He's sitting there looking at this Texas senator, this segregationist Texas senator who won his seat in the racist white primary system, telling him that they should outlaw the white primary system, which really takes a lot of chutzpah. Anyway, so I'm reading this very fascinating testimony, which I then found out, by the way, that Ken Mack at Harvard had shown to Dan Ernst, I think. And I talked to Ken Mack about this paper too. But so that paper comes up, fine, or that testimony comes up. Then in another class with Dan Ernst, I have to write a paper. And I think back to that previous, and this is a New Deal legal history seminar. And I say, oh, that was really interesting. But I come from an organizational politics background, including advocacy organizations,
Right.
including civil rights organizations. And my first thought was, well, where is the NAACP on this, right? They're the big sort
Right.
of player in this space. Again, coming from an institutional politics background, if you are known for something in a space and somebody else is testifying about it before Congress, that doesn't look good to you. It doesn't look good to your funders. And I sort of said to myself, well, why is that happening? Where is their position? This, of course, was during this course was virtual. It was during the pandemic. And so I was at home doing this by Zoom. And we worked with the Library of Congress. Normally in that course, Dan takes the students into the reading room. It was closed. So instead, we just connected directly with Library of Congress librarians who were scanning documents and sending them to us. And I think Loretta, I think was her name, was the one I was working with. I must have, Loretta Deaver, and I must have sent about 2 dozen, 3 dozen file requests. And she was just dutifully scanning everything that the NAACP had from 1937 in their files. And I was able to get into the meeting minutes and see that specifically they had been asked. I found this whole chain of the White House asking Mary McLeod Bethune, who's a
Mhm.
civil rights leader in DC, and
Mhm.
her bringing it to the NAACP, and they met about it and they talked about it. And Charles Hamilton Houston wrote a statement about it. And so, I was able to find all this information. And then I was talking to Laura Coleman, who's another professor, about this paper. And she said, oh, did you know that Charles Hamilton Houston wrote specifically that he was in favor of it in this other newspaper, this smaller Norfolk Daily News or whatever it was? And I was like, no, that's incredibly important. So she sort of found that key piece. It was a bit of a team effort. So anyway, then I was able to find the National Negro Congress, their files, and John P. Davis's files are in the Schoenberg Center in New York, and much of it was online. And I also looked to sort of get the atmospherics, the way that the larger Black community was thinking about this issue. There's several good databases that contain all of the Black newspapers, the historical Black newspapers, and there's a lot of commentary and news reporting and opinion pieces. And so, all of that together, and talking to all these experts in the field and looking through all those resources, I was able to sort of piece together a story of what happened, and then to fill in the blanks was able to think about the larger context of the civil rights movement in the 1930s. And to get back to the very start of your question, I think that part of the problem of the prior history, it's not a problem, but as you said, a focus of prior Supreme Court histories is really an elite history. It's really about these big decision makers, the Supreme Court, the Congress and the president. Partially that's because the sources are easier to find and more numerous, and partially that's because people tend to focus on larger decision makers. But I looked at this as a piece of social history because then, as now, the Supreme Court does not operate in a vacuum. It is not immune from larger political trends and context. And civil rights is an important part of that context. It is a crucial part of that context, especially given what was going to happen 20 years later in Brown and the direction that that was going to take civil rights and the role that the court was going to play in that direction. It's not enough to look at this as a piece of elite history or really as a piece of legal history. The court packing plan and civil rights are also, have a lot of social history. I also just find social history to be fascinating. I like to look at what people on the ground and organizations and individuals can do to alter the course of history.